Hello everyone. Welcome back to day 2 of our 2-day bootcamp on how to write an article. I am Yoshita Mandral and it's great to see all of you back for another productive session. Once again, we are honored to be joined by Dr. Rhea Roy, whose guidance yesterday was truly eye-opening. With her deep academic background, hand-on research expertise, and a commitment to accessible legal education, we couldn't have asked for a better mentor for this bootcamp. Let's dive into day 2 of this journey towards becoming a published legal writer. Over to you, ma'am.
Thank you so much. You've just energized me. Thank you so much for the nice, kind words.
Welcome.
Yes. Yoshita, did you bring your assignment along? Did you look at your homework?
Yes, ma'am.
Very good. You're safe. Okay. So I'm guessing, or most of you, I'm going to take it for granted that most of you have looked at it. Is there anyone who didn't have a chance to, identify your pre-done assignments?
Good evening, ma'am. This is my first
Hi,
day.
Disha. Yes.
This is my first day attending this boot camp, so I was
Okay.
not aware.
No worries. Because we were trying to look at how you're going to do, translate your assignment to articles. So we were in the process of trying to define that. And if you get a chance, please make sure you go back to the YouTube and go through what we're trying to work out. And Rokeya, you've not done an assignment in your college. Oh my God, you're going to be like on the hit list of so many people who are here. Right? Okay, so if not, we were looking at how we can have a research paper published, because one of the prime thing that we were discussing here is all of us do research in one way or the other. So even if people who don't do assignment as part of the college, you'd have done some kind of reading for your exam, right? Yeah, exam. I mean, I understand we have these guides. From where I come, we had a different set of guides. I'm sure from where you come, you have your local guides. But something you would have read to get a concept in. And I'm sure most of you who's present here, yes, not a research paper. But when you have done some kind of reading, there's something that spoke to you, that's made you wonder, why is it this way? And how are you going to translate that in a way it communicates to the other person? And when you question or try to answer why it's happening this way, what is that I would have preferred it to be some other means, is how you come out with the idea of a research paper. So yesterday's focus was to look at how do we convert an article or from an assignment to an article. And we were just trying to see that distance or the distinction that makes between a regular assignment submitted at college to one that's published is with research methodology. Then I wanted all of you to come back here with your assignment so that we could take it up for an example, right? So I want some volunteers, and we don't have much time today. So I'm going to quickly randomly pick people, maybe, let me see, any volunteers? Yoshita is going to be one volunteer by default because she was kind enough. Venkatesh, yes, Venkatesh, what was your topic again, Venkatesh? Because I'm going to be discussing a specific methodology as an example. Sorry, come again?
Am I audible, ma'am?
Yes, you are. You're very audible.
Yes, my assignment was regarding publishing a research paper in my second year, and the topic was basically regarding a scam that happened. It was done by a very famous company known as PayPal. With regards, I can explain it, but it will take time. So in short, it's just a scam, and it is more of a doctrinal research because we have to analyze.
Doctrinal research. Thank you so much. I wanted a doctrinal research because today I'm going to take a glimpse on that. Okay, so I'm going to take your topic and maybe try to see how it connects to you. So now all of you, when you look through your materials, right, and most of you, I'm going to presume, has conducted some kind of doctrinal. If anyone who's gone to a field, I know there's one person with GI who's in the field. Apart from that, anyone else who is done field, please put out in the chat box. But otherwise, I'm going to presume all of you have gone with an assignment on doctrinal research, which means you have touched upon literatures and primarily statute and case laws for your assignment. Now, what we're trying to do is, how are we going to convert this assignment of yours into an article using a doctrinal method? Now, let me tell you, this is just a glimpse of the course that I've shared because it's a long process for you to start practicing. All right. So, yes. So, what we do here is when we are looking at the idea of doctrinal legal research, it's not about randomly identifying some paper that you've referred to. Say, for example, when Venkatesh was looking at, let's say, a honey trap related to conducted by PayPal, uh, I'm just going to take some hypothetical situation, but Venkatesh, correct me, okay? Now, let's say PayPal. Okay, Venkatesh, can you tell me what the issue was so that I don't start
So
hypothetical
I
again?
won't take much of time. It's a bit of a broad issue,
Yeah.
but basically, Honey is a company, and it
Uh,
provides a browser. Every browser has certain extensions we use, such as ad blockers, etc. So Honey is an extension that you add to your browsers. What it does is when you buy something on the checkout page, it gives you discounts. So you are at Amazon, you're buying something, you go out to the checkout page, it will give you certain discounts. Let's say $2, $3, $5. But what happens is how do Honey gets their discount? So for example, if a content creator is there, he's into affiliate marketing. So he's promoting certain product, and when you click and buy from their link, the commission that is to be going towards that creator from which links you are buying. So if, for example, you are a consumer and you have Honey installed, so what happens is Honey poaches all of that revenue which is supposed to be going to the content creator, and rather it culminates and redirects the link to so that the all of the revenue will be going to Honey. But the problem is that consumer is not aware whether the commission is going to the preferred creator, which link they click. We just get $2, $3 discounts and we are okay. So on this entire deceptive practice, Honey has almost did a fraud of $1 billion. So this was the overall study. So it's basically
okay.
a case
So
study.
So can I'm going to case study. Perfect. On a larger context of, I'm just trying to figure out intermediary responsibility in e-commerce to understand.
Yes, so it is again a big scam. So the victims of these scams are not consumer itself, but rather the intermediaries, which are the content creators who are promoting certain type of good. So they are the
So
victims here.
this is under, what is your topic largely under when you're doing this case
So it
study?
comes under FTC regulations and the Lanham Act, etc. With regards to it is mainly focusing on the USA because Honey mainly operates in USA, but it also operates on a global level. The main audience that Honey is operating it is in the US.
Okay. So how, okay. So let me, I'm not an expert in this specific field about financial transactions and regulations. How can I, if I may ask you, since as Indian users, when I'm availing that as well, right, for my e-commerce purchase, I'm also a party to it, right? So
Yes,
are
yes.
you looking at, the Indian context as well?
Yes, I have discussed Indian context as well because nonetheless, we are also part of it. Though we are not aware it's such thing is happening on the back ends, but yes, we are a part of it. And then again, there are no such regulations, whether it be competition law or consumer laws that we have today. There is no such regulation that exists today. So there is a need for such regulation, which is the reason why I have suggested certain measures.
Okay. So as I understand rightly, we are looking at, just so that you know, we are looking at we are looking at how impact how let's say how intermediaries can be are compensated under yeah just to get a better clarity so that I can bring it under doctrinal research. Okay, so how intermediaries are compensated under the Indian regulation in case of these scams or financial losses, right? On a larger extent, can I
Yes,
say
yes,
that?
yes. Correct, correct.
Yes, yes. Okay. So in that regard, what would I be wanting to know as a researcher? Or what is it I'm trying to figure out? Saying that I've noticed that there's these scams that's happening where intermediaries are at loss or content creators are at loss. And this is because there is someone playing in between and law is silent and there's a gray area in between. Right? So you would have different, can be a similar scenario for people working where you have a purely statutory interpretation in question, because this is a matter of statutory interpretation to see that we don't have a provision under competition law, we don't have a provision, let's say IT Act, or we don't have a provision under consumer law. Many of these violations, because this is, when challenges come up, you have new scams that's coming up. So we are not equipped to handle these kind of scams. Or the first question is, does intermediary have a right, legally recognized right in these cases? Yeah, is it that they're waiving off their right? Is there in that digital platform, in such interference, is there a violation actually happening? I mean, when as a content creator, am I agreeing to such compromises saying that, okay, initially, if I am able to say, yes, Venkatesh, go ahead.
Yes, so there's another angle to it that many content creators have promoted honey as well.
That's where. So where I'm
Yes,
waiving
so
off my right
yes,
also.
yes. So under the brink of everything, honey has did all of this, and everyone was left in a gray area. So on one hand, there was a YouTuber in the case study I was mentioned. Is Linus Tech. He's a very big YouTuber. So from past 6 years, he has been promoting honey on his every single video, along with some other product that he wants to sell. So he's not aware that such thing is happening. But when everything was revealed, then he realized that almost 100 200 million dollars he has lost in revenue just because honey was poaching his affiliate commissions. So this is what is called, I have termed it as affiliate hijacking, basically.
Right. So now we have few factors here, okay? So when now let's say Venkatesh, you've taken it as a case study, but you're looking at a larger picture, keeping honey as a case study, but you have a larger picture of in case of intermediary liability in this case, intermediary loss, what is the legal responsibility of entities in such case? What is the dispute mechanism or dispute resolution model here? What are the statutory protection they're getting? So all of this is something that is taken up for consideration when you're taking the honey scam as an example. Now, what happens here is when you've done an assignment, I'm guessing you got it published, is what you said?
Yeah, it's still under review, but I am most likely it's going to be published.
Right. So when you have to take something of this kind and when you want to translate into a publication, now our first question here is, of course, what is the type of research? And this is primarily a doctoral research, as Venkatesh said. Now, why is it called a doctoral research? Most of you have engaged with doctoral research. Why do we call something as a doctoral research? Is because our primary source of data or information are statutes, regulations, and literatures. Now, what is important to understand here is when you start relying on these informations as data, how are you going to use them for your research? How did you come down to the conclusion that these are the information that is relevant for my study and they're not randomly chosen, right? So when we put it out as an article, say when Kirish has an article out there, he has to prove to the crowd saying, see, I've taken as honey scam. Now you would have started off as a scam paper and then taken up, evaluated, analyzed that scam and written a paper on it to look at what are the gray areas that's seen in this regard. Now, if I was to take a reverse order, trying to evaluate what is a general responsibility or protection entrusted on an intermediary, ensuring that they are safeguarded in these platforms, or what is the kind of agreement that people enter into. So there are multiple laws that come up in this case. So in these cases, there are few keywords that comes relevant here. So the moment you have this specific area of, let's say, one is on intermediary protection. The other would be about transactions. How do you ensure transparency in this regard? Or however, we have to make sure our arguments are backed up by evidences. Now, when I'm going to say it's backed up by evidences, you have two ways. One, of course, is where you have stakeholder interaction, that you actually interact with these YouTubers, which become your empirical study. Now, when it's a purely doctrinal, you have to say that your backed up evidences will go back to the literatures saying that, see, when it comes to an intermediary protection, there's established rules. Now, this doesn't stop with intermediate protection. Jurisdiction becomes an issue. So if you look at it, a situation like this is a broader picture of questioning. So what happens in case this violation happens in a specific jurisdiction? I'm sure there will be set rules. I'm sure there's set rules about identifying jurisdiction. But in case of these jurisdictions, where are they operating from? the protection, and what are the theories that's developed? How do you say that they even enjoy this protection the moment waiver of this right has come? Because a person who's promoting this entity, what is the prima facie evidence say? That I've agreed to the terms and conditions of this entity that I'm promoting, right? The moment I've promoted this for a considerable period of time, then I figure out that I've experienced a loss. What is my legal right in this scenario? Are you with me? And this is not just in case of this. Now, more importantly, in case of the social media marketing and likewise. So, what is the literature that's governing in case of waiver of right, waiver of legal right? So, what do we have to do? Now, you have to identify areas that crucial legal principle that's reflected there. Now, all of you, I'm sure, in your assignment, you have done that. When you are talking about, let's say, more assignments, let's say when you talked about, I'm looking for, can you put in some more assignments in the chat just to take multiple examples? So, put in most assignment examples. So when you start looking at these legal principles and all of that, you've identified what is getting violated, right? So you have two kind of sources that you rely on. Of course, a primary source, which is validated by an authority, which is a statute, case laws, constitutional decisions. Then you have the secondary source, which is important. Those are the government reports, and they have hierarchy based on which you're facing them. Now, when I'm going to look at, let's say, Kausar, the one we were taking yesterday. When you're talking about a Supreme Court bias on marriage laws and how Supreme Court decides case on gender bias, and where you have Supreme Court itself raising a caution with the exercise of 498A, what are we trying to look out here? Now, Kausar would have to look at, okay, what was the entire purpose of 498A first being in place? What was the idea of the Supreme Court when they made that shift, right? When they made a shift to say that it can no longer be a non-bailable offense the way it exists in BNS, but you have to take the precaution before you actually enforce or evoke that provision. Now, in the feministic jurisprudence, or you have theories, difference of perceiving. Yes, I'm just taking an example for, easy understanding, right? But nevertheless, what we have to do here is, what are the literatures that you're going to base yourself on? So you would have people who have evaluated judgments, and I would say this is more of a case law analysis mechanism. A case law analysis which is going to evaluate, I would coin it as a discourse analysis. This could go into the terminology, will go into Parvati's relation about live-in relation conflict between personal law and statutory law, where when you're looking at the mentality of the judges while coming out with a judgment or Russley, you're trying to understand what were the factors or terminologies, very important, that the judges has used while making a deviance. Are you with me till here? So we have the term called gender bias. And now we have some of the terminologies where the presumption lying on the women as a victim. Now, I don't believe that you can presume it in that way, though, yes, over a prolonged period of time, women has been the victim. But we cannot deny the fact that there's been excessive miscarriage of judgment by such presumption, where the courts have tried in some judgments to make a shift. So when you're taking up this particular analysis, you would have a case law analysis to evaluate the mental shift of, how judgments work. Now, how are you going to choose these judgments? You're going to be humpty lot of judgments on this scenario. Divorces that get to Supreme Court. The way they claim their grounds. How it's evaluated. How judges come down to this conclusion. Every day, from all these high courts, you have umpty number of judgments that get there. How are you going to screen these literatures? Right? So how you do that is what makes that methodological difference. Okay. Now that we understood that we have these sources of literature, right? We're going to do this. We're going to try and filter the literature. This would primarily go with, let's say, the secondary source of literature, because primary we are clear. So I'm going to keep aside the case laws for now and then come back to it. Are you with me? Now what I'm going to do is, I've got so many articles, right? Now let's say I've got a lot of Parvati's topic about conflict between live-in and personal law. As simple as live-in relationship being recognized as marriage. The personal law doesn't recognize live-in relationship as marriage. Only, and what happens in case of succession? What happens? You have a live-in relation or domestic partner. Now, what would Parvati want to do? Parvati will try to see what is the existing writings, scopus indexed, peer reviewed, projects, government study about DV Act, definition, because that's where live-in relationship concept has come in. And when Parvati is Parvati, right? Or Pavitra?
It's Pavitra, ma'am.
Pavitra, I'm sorry. Oh my God, I would have given your topic to Parvati. And you still tolerated me. Okay. Pavitra's topic to say, I'll be looking at how live-in relationship has been defined. And I would see in literatures to see that, okay, most of the time, where Venkatwami's case, right? Pachamal, who gave us the first decision in 2010 to say live-in relationship in the nature of marriage. Now that's not the same application when it comes to personal laws. So what would I do? I would search in Heen, live law, everywhere to see what has been the social understanding about it. They would say, okay, live-in relationship is protected under Domestic Violence Act, which also gives you a level of compensation in case of some violations. And in such case, Velusamy versus Pachiyamma, where you also try to get literatures that talk about, in such case, you get protection, but not under personal law. Now, there Pavitra has identified a gap saying, well, it defeats the entire purpose of recognizing a live-in relationship. Now, Pavitra wants to understand why is live-in relationship not recognized under personal law for the purpose of benefit of the partner involved. All right, Pavitra? So that is the research gap that you've identified. So what do you do now? You have two ways you've used your literature. So you're going to have some literatures that help you understand the concept. Then you have literatures that where you are going to say that, see, most of them spoke about what the context of live-in relationship is, but does not talk about how you see it in personal laws. Now your idea is to see is, next step is to see, okay, when I go into now my area of literature would be to look at how is marriage viewed or, these kind of domestic relations viewed in personal laws. Now let me tell you this, Pavitra, when you look at this topic, till 2009 judgment, registration of marriage was also not mandatory. So, there was a presumption of marriage if you live together for 12 years, right? So you have a history, as in India has a history where if you had certain practices which were sufficient to be treated as a marriage or for domestic relation, of course, that created chaos that finally we had to come up with registration. Now you will look at literatures on that to say that there was a time when we had relationship which was still recognized as marriage, that it's not just the mandatory registration, but there was some of these relationships that got recognized. Now, when I identify this, I'm going to see Humpty lot of literatures like common law partner, because even in common law partner, interestingly, when you have visa application, that's the ground they ask. Common law partner, right? So in case of common law partner, different partnership that we're talking about, you cannot read all literatures on it. Then you start filtering them. Now, how are you going to start filtering them? We would start filtering them using a mechanism called as predefined parameters. Remember what we spoke about? How do we define these parameters? The first thing, that's why your research objective and research question becomes very, very important. What is that you want to understand? Do you want them to be protected under personal laws, or do you want to simply understand how it's viewed under personal law? All right. Now, what is that you want to answer through it? That's the lack of protection leaving. Maybe I'm just going to give you a hypothetical scenario where it's leaving people at a stake and apprehensive which is, I'm just going to take it as far-fetched to say, non-recognition of these relationships is also a factor of increase in divorce rates, because people wouldn't want to enter into a marriage but supposed to get into a marriage only for the legal protection. Okay, I'm just giving you a situation, an example of a research question. That it's actually resource wastage. The moment you start recognizing this relationship. All right. So when you set out parameters based on the research objective, research question rightfully formulated, you're able to identify, okay, I'm going to translate or structure my paper into different categories. Got it? And once, because one thing that you need to get a grip on through your course of study and during your employment option itself is, how do you set these basic parameters set, like the objective, questions, problem, because that sets the tone. All right. Once that's done, then it's about having a correct analysis. And these analysis, how you bring it about, it's what is going to distinguish an assignment from an article. Are you with me? So we're going to take two types with maybe two case examples that I have here. So I'm going to take Pavitras for instance, okay? Pavitras and Kausavs for instance, and Venkatesh, of course. Now, when you look at, let's say I'm going to take it, okay, Kausavs. When you're talking about case law analysis, yeah, go ahead.
I can give you the case law. I have a reference.
Brilliant. I think this makes our life easier. Okay. So how did you come down to deciding these are the case laws that you want to evaluate?
This was the very reason I started to do this research. And this case law was the very point where I had this sudden idea that I should research on this. I told me this yesterday. I was quoting this Shobharani versus Madhukar Reddy.
Yes.
This was the case, ma'am. Today I was searching my book and I got this.
So tell me this, when you know that, so that was your motivation for research, that when you notice a difference in judicial attitude, now for you to put it out as a paper or an assignment, you need to go back and evaluate some more cases, similar grounds, right? What was the ground taken in this case? Oh, did I lose him?
The cruelty was rejected on the petition.
What was the ground taken for divorce or the?
Hello?
Yeah. Can you tell me the ground?
And the ground was cruelty.
Cruelty. And on the similar ground of cruelty, in one case you notice where the woman was the petitioner, it was allowed. Whereas when man or the husband was the petitioner, it was dismissed.
Yes, sir.
Yes. Now, within cruelty, when you claim cruelty, there could be, I'm just taking it as an example, okay? There would be grounds of cruelty, right? A cause that's led to be defined as cruelty. It could be a physical abuse, mental abuse. Mostly these kind of confusion happens in mental abuse. Mental or emotional abuse. When I take a mental or emotional abuse, it's a gray area or an abstract area. So, Kausav, now what your challenge here is, not a challenge, actually the whole research would be, you would have to identify, or I'm sure you are in the process of identifying, what are the similar kind of cases that's done, already done. So you'll start digging up some more cases to see if there was a pattern. And because you cannot take, this one case would be your inspiration for research. But that alone cannot be a factor of research. So what you would do is you would go back and figure out, okay, I'm going to take cases that's reached Supreme Court on the ground of cruelty. One. Once I've identified that, you would see there's a lot of cases, because cruelty again is a very broad concept. Physical cruelty, leaving aside physical cruelty, mental and emotional cruelty. You didn't smile at me is a good cruelty ground. Right. Then I came back from office and you didn't smile at me. Now, keeping that in mind, you would have to start filtering out cases where looking at who are the appellants in these cases. Yes, sir.
Ma'am, I have the cases, ma'am. I have this Shobha Rani versus Madhukar Reddy. I have Dastan versus Dastan. In both of these cases, these are cruelty grounds. Both of these were from the men's side. The petition was from the man's side. And then I have B Bhavla versus and this Samar Ghosh versus Jaya Ghosh. These petitions were from the female side of the end of this marriage. So
very good.
All these four cases, the ground of cruelty. No, there is the divorce.
But how was the definition of cruelty in all of the four cases?
All of them are mostly physical. 3 of them are physical. 1 of them is mental.
So now when you pick out, this is where, when you want to make it into a paper, right? Look out for a specific area of definition of cruelty. Or when you're looking at a broader structure of cruelty definition. Okay, let's take physical and mental itself. All right. Now, when you want to claim a bias with the courts, you have to be a little more cautious to say, I have not restricted myself to just 4 cases. Look out where, how do we decide the number is going to be a little tricky then. But definitely look out for a time span. Maybe those which have become precedents. How many cases have reached to Supreme Court in cruelty? Then you start filtering it out. Of course, there'll be a lot, but you start filtering out to see that in terms of definition of cruelty, right? Once you're filtered out on definition of cruelty, you would start, because when you want to trace a pattern, you would have to have substantial number of cases to say that you have done something like this. Got it? To filter out that you've taken, like say, 10 cases, bifurcated the rationale, the grounds, the appellant, the party to it who has gone for an appeal, definition of cruelty, how it was defined, what was the rationale cited by the court in this case. And in that, you would see what were the cases referred to the court in those cases, right? To see that most of the cases dismissed had
Ma'am, you're not audible.
In between, I got muted. All right. When you show that there's a substantial number of cases showcasing that pattern, because what are you trying to do here? Because especially when you're trying to make a criticism on the judicial system, you would have to have a solid evidence to back you with that argument. Right? And that moment, when you start showcasing that numerically, because what you're doing is doctrinal method. But when the doctrinal method is translated to say 70% of the cases, first thing you do is you would give a justification of choice of cases. Are you with me? All of you who would like to go for case law. Once you've given a justification in the way that you've chosen the case, like the Supreme Court judgments, I've relied on Supreme Court judgments. It might be a jurisdiction. It might be the number of judges. It might be the ground. It might be the duration that the case would have taken. You would have your reasons based on your objective and research question, right? Once you've got your justification, then what you're going to do is you would say that I didn't randomly choose my answers from here and there. I have filtered or analyzed my cases through different mechanisms which I am portraying here. Are you with me? Now, what the good thing it does is, there you have an argument that's evidence-based, which the authors or the readers would want to find out. That if they have to challenge your argument, we'd have to do the equal amount of work to come back with questions, because you're not denying that courts have seen it otherwise. But the pattern, which is 70% or which is in the majority, showcases this. Did you get that concept? Of course, it's going to take a bit of time and practice to sit down with your paper and work on it. So always put 1 month to 2 months with these methodology elements that you rework, go back and forth while you do this. Are you with me? But did you get the concept here? Let me know if it's going above your head or it doesn't make sense.
No, ma'am, it's okay.
It's okay?
Understood.
Yeah. Now I'm just going to take, now similarly, I'm going to take something else in case of Pavitra's personal law element. Okay. Now, when it comes to a personal law case, if you're writing an assignment for family law or if you're writing an assignment for interpretation of statute, I'm sure all of you would be learning interpretation of statute soon. And it's a beautiful paper, and I think all of you should try to make a paper, your assignment into an article there. What you do there is, it's all about the wordings of the statute. How many of you studied evidence? I mean, now the amended version of it. Okay. How many of you have seen a statute? Law, barracks. Everyone. Yoshita, everyone would have seen it. Now, have you noticed these wordings like may and shall? May and shall? Yeah. Isn't it funny that a punishment would be based on how we interpret or the wording used in the statute with may and shall, where it talks about a mandatory or a compelling nature against an optional nature. Okay? Now, what happens here? You are interpreting the language of a statute to understand what is the intention behind that specific statute. Are you with me? So the moment you're looking at a personal law and the relationship question here, you're trying to understand a language. So live-in relationship and personal laws. Exactly. So when you have that personal law element here, interestingly, when you have succession, for example, the right of a partner is only if you are legally married to the person. So if a husband dies, right? A person who lived with that person, with that deceased, who believed themselves to have a matrimonial relationship but did not want to take a legal obligation for whatsoever be the reason. The question here is, where does this leave her in terms of his estate? Pavitra, is this something that you want to look at? Pavitra? Yeah. So now, it's all right if he doesn't have any siblings or he doesn't have anyone who's questioning it. But even then, law doesn't recognize you as a legal heir to that property. Right? So even if you are to claim the property, you're not going to get it unless he's written a will in your name. And most of the time, what people do the last, unless you're in death, but they don't write a will. Most of them. Because it's the last thing they want to do. Now, what happens here is, and this person wants to challenge it. You see, what is the domestic relationship or marriage element that these personal laws are talking about? Now, when you look at, let's say, if you have photos or when you talk about marriage laws or likewise, we are looking at a scenario where is it the prerequisite of that marriage? Because Hindu marriage would have something and not necessarily a registration. That might be different when it comes to Christian marriage. So is it sufficient to say that we have conducted religious ceremonies? What happens if you don't have a religious ceremony but you lived and portrayed yourself as a husband and wife? Then you would start looking at the language of the law in place and you would start looking at what was the reason for this transition? This cannot be the same case when it is a 2-year relationship and this person dies. But this, and it cannot be a 20-year relationship cannot be placed in a 2-year relationship. Are you with me? Now, this also questions about when you have a child in this relationship. I think you're familiar with Kushbu's case, right? This was a scenario that also took into consideration the situation there. So there, all you would have to go back to understand what was the mindset of the legislation when they spoke about it, or what was the mindset of the courts not to touch upon these personal laws. That do they have, or is there a probability that this gets extended to personal laws as well? Are you with me? Got it? So the moment you're using these words, so this similarly goes to understanding prejudice and emphasize on severity of two-case analysis in prominent jurisdiction. Legal implication of IMO Convention and clause vessels, crewless vessels. Oh my. Okay, you're all way advanced. Right? So even in case of, say, scams. Now when we're talking about honey scam cases, the honey scams case, you have these gray areas. Now, when we're talking about intermediary responsibility, you would have noticed in the IT Act, at least in the Indian context, where the liability or responsibility of intermediary, the regulation itself is a gray area. Because most of the time we have difficulty trying to find out to what extent they were able to monitor this. Because you would have to, because of the large volume of interaction that's happening. So you don't really have a space to evaluate all of these interactions. Now, then you come down to defining what is a clause or the standard contract that all of them would have agreed with. So when the content creators have got into a collaboration or a collaborative contract with these products or advertisers or entities, they have a standard contract they've entered into, which would have spoken about certain waive-offs and obligations, right? Now, otherwise it becomes a contractual breach. Now, then the question is, what would be constituting a contractual breach in a standard contract? Are you with me? So in all of these scenarios, what we're trying to tell them is, see, now you don't have a clear-cut literature to be identified. Like, say, in case of Venkatesh, the scenario is you have some statutes, you have a case study that's in place, where you have a gray area that you're trying to evaluate. So what you're trying to do is, okay, you might not have such a lot of literatures in place, but what you're going to try and do is, see, then I'm going to try and enter into a discourse analysis, trying to understand the language and the interpretation of this language used while the intermediaries get into a contract with the promoters or entities, and what is a contractual obligation, and in case of violations, what is the liability that would rise. And in case they voluntarily entered into these kind of waive-offs, can they claim in case of excessive abuse? What is the threshold that's set in place? Does that waive-off speak of a reasonable threshold? Are you with me? The entire point here is that you don't randomly draw out information. You will tell the readers that your paper has been based on some scientific. So you can probably underline the word and go back and try and figure out what scientific means. Systematic and scientific. Got it? So similarly, you will actually see in as common as doctrinal, you have other way of analysis. Like, say, you have thematic analysis. How you bifurcate them under different themes. Or you have something called as a content analysis here. What is the context in which that law was in place? What was the idea that law was in place at that particular point? Got it? So in that way, the moment you start tweeting, with all the information that you've already collected in your assignment, you start tweeting them, you would see that this becomes an element of sufficient material for an article. So take a moment, maybe go back today, go through different journals, well recognized journals. You will notice that the information they use are similar to what you collected. What makes that difference is the way they've used and identified. So maybe you can underline the term. First is about process of identifying the source of information. Are you with me? Which becomes your data. Did you get that? Please, somewhere note it down. Okay? Once you have justified your source and the scientific element behind that identification, what you do and how do you do this becomes the second element. Okay? The moment you are able to justify this, you have a brilliant piece worth publishing. Then the question from the reviewer to ask, how did you come down to this conclusion is answered? That they would want to consider your paper. Are you with me? Yes. Because now when you're talking about different perceptions, you're going to be talking about discourse analysis in the case law analysis itself. You're going to see what were the judges thinking. So what are you trying to do there? What was running through the judge's mind? Are you with me? So what I'm going to do now is take 5 minutes to look at different assignment topics that we have here and see what kind of doctoral method that you can probably put into practice and translate it into a article. Yeah? For which I would need you to, I'm going to stop presenting, and for that I would need you to start talking. I'm waiting. As I start calling names. The moment I say I start calling names, so people leave the meeting. Tell me your topic or assignments so that we can try and identify, so I can take examples so that we start identifying what are the different methodologies that we can use for that translation. How do you make an assignment into an article? And since yeah. Yeah. Yeah, that's what. So one, like, for example, what we looked at is when we were looking at yours, we were looking at case law analysis with the discourse analysis, right? Now, how are you going to identify the case laws, and all of that is a process? What is the justification that you would give while number of cases that you chose? Why did you decide to, I don't know why this is happening. Oh, is it? That's nice. That lightens the mood. Okay, why this has happened and all of that. You would have to decide. So similarly, how are you going to example? So you would have a part in your paper, one paragraph that talks about methodology. That is a very compelling area. That's actually a game changer if you look at it. And when you put out the analysis, you use these terminologies for analysis. Right? Say, for example, I have Disha's topic, One Nation, One Tax. As GST truly unified India's market. So when you, okay, then my question, Disha, is can you speak to say about what is that you would want to find out?
Ma'am, what will be the appropriate research methodology for this topic?
Yes. So from us to identify the methodology, are you going to look at So we have GST in place from 2013, right? Or 18? 18.
2018.
2018, right? 2018. Now we have GST in place from 2018. Now, when you look at GST in place, so again, tax is not my strong area, but I'm just taking an example. When I'm going to evaluate, I have to look at to see how GST has been in place and how it's functioned. And one of the best ways to look at it is the number of cases that would have come up in this regard. So I'm going to look at what were the kind of challenges that was raised in terms of GST. Was there a tax variance? Or was it excessive taxing? Or was it about double taxing? Or what is it? What was the first would be to understand what was the objective of GST and to see how it has reflected and what were the case laws that was in place to see if it has achieved or not. If you're looking at a doctrinal. So one of the best ways that you can look through is a case law analysis to say that with the number of GST cases, the challenges faced in terms of transition were cases that looked at double taxings. Maybe I'm not wrong. And that would give us an example to say, okay, what was existing in these patterns? Are you with me?
Yes, ma'am.
Before the tribunal. Yeah. Online survey. The moment it comes to that, it becomes, then if you want to look at that, then you have to design empirical research. Then if you have to design an empirical research, you have to identify who are your stakeholders. How did you identify your stakeholders? What was the sample size you decided? Whoa. How did you decide this were the number of sample sizes? Of course, there are these mechanisms that would you do. And then you would say that, okay, when I spoke, did you speak to all the stakeholders? Or are you only dealing with people who are applying for a GST? Or are you talking to consumers who are paying GST? Yeah. So did you that mode? So when it comes to an empirical, your methodology entirely changes. And when you want to use empirical for a paper, you have to be a little more careful. Okay. So what you can do in that case is if you're sure you want to do empirical, it's totally doable. All right. Just make sure you predefine the model. For example, an empirical could be in terms of an exploratory research, or it could be pre-identifying the stakeholders to say, I'm only concerned about GST holders, right? Not the consumers, but the business holders and their experience with GST. And I'm going to look at small scale business holders and how do I define small scale business holders. This from, from the land, like say 40 lakhs is what GST, if you have to mandatorily get, right? So 40 to 80 lakh or 1 crore turnover, maybe small scale. So what was that you wanted to understand from these consumers? So what were the predefined research questions in that? What was the presumption that you started off with? Because if you want to use them to get them translated into a paper that goes out, or even for an assignment, that you get solid input, have this in mind. Because you can ask them questions like, I don't know what the questions, I'm hoping that you had strong questions, but the questions like, okay, do you pay GST? Are you happy with the amount that you paid? Do you feel that you're paying much more than what was before GST? I don't know, the kind of questions that you probably would have asked. How do you validate these questions? Right? Because when a reviewer comes back with that question, or as simple as if you want to be a tax practitioner, this exercise helps you understand the provision better. This is where the idea of practical implication come in picture. So it's not just about having an article out there. It's about having a solid input about how the provision was invoked or what is that consumers face while handling GST. That when you want to be a tax practitioner, what would you take care of? Are you with me? That is how research methodology helps you. So we're talking about developing that skill through methodology. Are you with me? So it's not just about having an academic writing. Thank you, Tisha. That's a very important point I wanted to actually discuss in class about. When we talk about research methodology, it's not just about an academic writing. It's about how are you developing that skill so that even when the information is replaced, you have gathered it to decipher and utilize the same skill to come out with a different set of conclusion. Does it make sense? So now when you're using consumers, I would say empirical. In case of empirical, I would want you to take care of few things. Um because I haven't discussed empirical, I'm trying to tell you a word. It's going to be a quantitative mechanism, but do you want to do quantitative? Because what do you want to understand from the stakeholders? And I'm taking too much of time, but still. What is it you would want the consumers to understand? Do you have a category of consumers you're looking at? Like the, how did you choose your consumers? Was there a pattern? Disha? Yeah. So because now what happens, like you could have students who, or people like me who doesn't know, I'm paying GST, yeah? And I wouldn't mind, but you would have consumers who, were very careful about what they do. So you're a mixed crowd. So you should also question that competence of the consumers as well, like, the occupation. So you would have a first set to know the profile, that how familiar are you with these concepts before you go into the depth of question. Yeah, so take care of those that will help you. Yeah, so that you know how you interpret these provisions as well. Got it? Perfect. So yeah, I think from with this about how we're doing article, we've come down to this to tell you one thing is that I would strongly recommend the fact that so I need to start with intro needs case. I would say, see, Disha, if you have time, empirical is okay, but you are pressed against time. Try to see how GST related cases have been filed by consumers. If I'm sure there are a humpty lot of cases. What were their arguments? Go for that. That you are able to do it quicker. Are you with me? Maybe you could put a month's time and how you do these analysis using the case law. I would suggest that you do that at this point. Then take it forward as a next level to evaluate what were the stakeholder perception. Consumer perception. Then we can streamline who are the consumers you want to look at, and likewise, because that would require a little more time for you to streamline it, and manpower and evaluation capacity. Yeah. So the moral of the story that I want to send out here is, irrespective of how you translate your work or not into an article, to engage with law in its totality, make sure you have a grip over methodology, because that's a skill development which gets important through your exercise. Through your practice about in your practical life. You choose litigation, document analysis, compliance, or however. People survive without it also. But how you quickly get into that field and work through it, it's like an inbuilt filter system that you work. All right. And then also an off record tip is it works in your personal life as well. When you want to evaluate, picking your battles, and as you proceed with life, your analysis become better. It's a skill shaping. It's a fundamental, I would say, of any skill that you want to develop through your law degree. Right. So with that, I think we come to the theoretical side of the boot camp, and I hope I made some sense. And I would like to, and I think Sriyanshu would also join me here to introduce you to the course that's up on as a MOOC platform, and the precs that come with it for all of you. So I think I would give the space to Sriyanshu. you there?
Yes, ma'am. Am I audible?
Yes. Yes. Yes.
Great. So we are launching this course with ma'am, right? So I would also like to share a link in the chat box if you guys would like to visit it out. So, ma'am, I have thought that we would be sharing it in the groups after that. I believe that would also be fine. Otherwise, what I could do is I could
That's
just
absolutely okay.
yeah, I could just share my screen, take you to there, and you could just discuss that what all content is going to be discussed.
Absolutely. Absolutely. Okay, I'm going to unpin me and then, yes, please go ahead so I can just run you through the course. And one of the things that I want to happily share is it's actually a portion and we are in discussion to increase the content as well in terms of qualitative research. And this is paper that I'm offering. I teach at Leiden University. And this is something that is mandatorily required by the students to take in the graduate level. And we're so happy that Srianshu offered this platform, and he was very particular that we make sure, because I was asking him one of the things that, wouldn't it all be more course available otherwise, and it be, available to the students otherwise. And one thing I really loved about Legal Specs is that they said we want to target specifically to Indian students with the examples and the system they are in. So then we have curated the course in a way that, of course, the literatures that you would have a bit of Western touch because they have a very strong research backing, but the materials developed is something that's close to what you deal with in a regular day, everyday life. So it's something that's customized for our academic structure, taking inspiration and content from what you see in this site. By now you know that I teach at Leiden University, so we've taken content from there and the materials that's shared out here, customized to suit all your needs. Yeah. So yes, Shranshu, please go ahead and share the screen.
Okay, I believe I'll share my screen. Yeah. Is my screen visible? Is my screen visible? Like, could you please confirm?
Yeah.
Okay, great. So this is the course material we are talking about. We are also providing some exclusive discounts. So what I would like, ma'am, is for you to just discuss the content pattern so that the students are aware.
Yeah.
Yeah.
All right. So what we've done through this is it's from basic about concept of research to how do we the assignments or the content that you have, how do we identify, now you have identified a topic, how do you streamline it in terms of an article, or how do you streamline it for a general research purpose. Then within that, how are we trying to, and each step by step to see, okay, how am I going to say this is the problem that I'm going to try and find a solution to. How does this help you not just in article, it would help you to see when you want to advise a solution to a, let's say, a client. Now it all starts off with making the right diagnosis. As a, just like a doctor, as a legal person, we are all entrusted with the duty to do the right diagnosis. And how do we make the right diagnosis is discussed through research problem and the process in which you would go through it. Thereafter, then we talk about what is the idea of, okay, what is that answers or the research question that we try to figure out and answer. How do you formulate these research questions? Going further, when you want to go in depth to understand, okay, do I have a presumption that how am I going to prove or disprove it? How do I develop that pre-filter mechanism that I was talking about? Going into different research design, doctrinal, non-doctrinal, empirical, however you want it, it's blurred. Then discussing about, okay, how do I decide my data? What is the sample size that I would have to choose when it's an empirical, if it's a qualitative, if it's a doctrinal, how do I design on that? How do I record it? Now, it's not enough that I have all of this information in hand, right? How do I put it into a way that is understandable to the public? Got it? So all of this, to the way it's getting recorded, how do I use AI to my benefit within the academic integrity, taking it forward, different tools, likewise. And of course, to a step forward for the masters, and otherwise, if you decide to do a bachelor thesis or a dissertation, that also goes in. Along with this, I believe we've also added reading materials to it. Some of the literatures that's I personally would really recommend, and something that I share with my students on a regular note, and they have come back with positive feedbacks, is also given here, because each of these articles, if we were to get it from outside, is like 30 euros, 35 euros, because most of them are like print your sake, those kind of authorities that kind justifies, when you simply have them put out in your paper, it speaks quantity of value to what you're writing, because they are the peer review or the process that gets an article through speaks of its quality, right? So that is what we have here in the course. And of course, Sriyanshu is here with some of these offers that for you. Yeah.
Yes, ma'am.
And I would also like to just add on to say that we were just discussing, and I understand that all of you in the process of your undergraduate, where we were thinking maybe for the few enrollees, I would be there as a personal mentor, at least a personal mentor for limited number of students. That I maybe Sriyanshu, we have to decide number of students, the first 10 or 20, for them to translate their assignment to an article or in a way that can be into a publishable quality. In one session, and of course a review on mail. So it's not, please don't, it's not like this back and forth business. That you have a session, we streamline it, we work it out, you get your review, you restructure it, and then you get a review back to say that, yes, this is an article form, right? So see if this suits you and if it works for you. And it would be nice that you have this. Trust me, working in both the sides of the world, one thing I've seen the difference is this. One primary, of course, is. Yeah. But that's about from my side, and it was so nice to have such a vibrant, nice crowd.